the first to know Nsem-Pii TV.
Meno kasa idea se ukopiemu ewo mrashe bedefia enye asem kotwa ene dom kuma ne trese one ene dom kese for now sanso ena dom kese nso epese o trese one ena eye dom kese me tre majority na NDC minority no eba bepiemu mrashe bedefia ena one ebe occupy NPP majority space no eno ena nso said afenoma can do to dwa enra se NDC amanyoko ni try say one e de basa ebeba enya ade say one ebe retaliate e ya ade say one ebe sorry na wa free chamber ho boko enti one e sorry free chamber ho until say urban semana Kingsford Bagbin etimi eba bedu chamber ho na Bagbin so ebedu chamber ho no na watimi akatere na lawyer for say wonko piemu e wo Supreme Court. Na the Supreme Court ekaye no bonso enko na onkoye yenko ni enkotie abansmana Kingsford Bagbin ono a lawyers akwakopi mu Supreme Court
get some outcome that will inure to the benefit of this great country and our democracy. I don't know how successful this has been, but we will see what he says.
Well, let me come in at this point, Evans. News reaching us is that the Speaker has asked his lawyers to file an action in the Supreme Court to stay the Supreme Court's order. And that's just coming in from our Parliamentary Affairs correspondent, Kweku Asante. We'll take you to Parliament shortly, but Evans, please make your point. Yeah,
but that's the point. I mean, that developing story is important. That is the right thing to do. That is the only course of action that a democracy is expected to chart. And we shouldn't follow what happened in Capitol in the U.S., where a certain president masses people to the Capitol Hill and led to violence that led to people's dying. We can show the way, and so if he sent his lawyers to the Supreme Court to set this injunction aside, is the right thing to do. Now, it actually then places the burden back on the Supreme Court, because the expeditious nature that they approached the first application with, now we want to see if they're going to apply the same expedition to this application also.
Same day, same day.
Yes.
Dealt with dispatch. Supreme Court 5-member panel assembled on Friday to deal with the matter expeditiously.
When it was filed on Thursday.
Yeah. So it will be interesting. I mean, I agree with you. It's an interesting development. That's if it's filed today, will the Supreme Court be able to equally assemble? Because the president should have said, and they said demand they can also make. And I've heard lawyers say,
they must assemble themselves.
Yes, yeah. If you don't do that, you send a different signal to everybody.
So this is interesting. There's another part of this developing story that it's important that our correspondent in Parliament is clarifying that his understanding is that this process that the Speaker has asked to be filed may be filed before proceedings begin.
Today.
And the Speaker takes his chair. And I think that is signaling something very clearly. Once it is filed, he can come to the House and says it has...
Nothing should be done to offend the import of that particular
until it is decided.
So it returns to, I mean, it's status quo ante, right?
Absolutely.
Original declaration that he made.
Stands.
Except that the stay that was agreed, that the court agreed to, was to stop him from making those seats vacant. So the 4 members of Parliament can walk in today and go and sit in their seat.
That's true.
If the Speaker says, I have filed, and by you coming to sit in your seat, you are really defeating the purpose of me filing.
So you can't sit in your seat.
You can't sit in your seat. It will be an interesting
wait for me, the fact that our correspondent adds that second bit, and of course, once the Speaker's direction to his lawyers is that I'm waiting for you to file. He could have gone in there and sat and of course did his
work. The day,
But once he asked that, go and file before I get in, clearly you know where this is going. He's going to come and say,
but
because I have filed.
The good thing about this is that you're using law to solve a problem created by law.
So, yes, you see,
no, which is on the face of it, a very sensible. We were afraid. We were afraid that it was going to be 2 institutions head on.
This is
disregarding.
This is a sensible thing to do. If the Speaker does that, it means that and even if he comes out to say, because of that, my understanding is that these persons cannot come. That's his understanding because he's resorted to the courts to actually set aside the court's own ruling. While you wait for the court, and we say justice must not only be served, but must be seen as being served, we also now will begin to count down on when the Supreme Court is going to come out and say, okay, we're going to listen to your case. Because if the Supreme Court could do it in the case of the NPP, you expect that they should be able to do it in the case of the Speaker. No problem. But at least the good thing is that the Speaker, if this is anything he's going to do, is resorting to the courts in dealing with the challenges that the courts may have put in his way. And for me, that's the way to go.
You said the law to fight the law. I'll come back in studio, but let me bring in Dr. Kojo Asante with CDD. And we're just getting an update from Parliament that the Speaker has asked his lawyers, to file an action in the Supreme Court to stay the order of the Supreme Court. You have been calling for cool heads to prevail. What's your thoughts about how things have panned out in Parliament this morning?
Good morning. Yes, I think that is what needed to be done because I think the worry was for the Speaker to ignore the directions of the Supreme Court. That would have been unprecedented, because that would have been the Parliament of Ghana ignoring directions from the Supreme Court. And that signal would have been really problematic. It would have been completely unprecedented in the annals of the Fourth Republic. And so that needed to be avoided. Whatever the objections were or disagreements with the judgment of the Supreme Court, the intervention of the Supreme Court, the only recourse was to use that same process to challenge the Supreme Court's own actions. And I think one of the options was to apply to set it aside, or to go ahead and file the statement of case as had been instructed by the Supreme Court. And so I think this is the right move, and then everything else would flow from there. And I think that would help at least resolve matters in the interim and direct Parliament appropriately.
We've been hearing from Professor Kwesi Enin this morning, and he argues that the conduct of our MPs in the House is clearly in blatant disregard of law and order. They say that they create the laws, but they fail to respect them. How do you feel we can allow cool heads to prevail in Parliament post this event?
I mean, even in terms of parliamentary practice, I've been really surprised by this whole behavior of the caucuses, because really the issue about minority and majority, given the Speaker's ruling on Thursday, even if there was a change or a change in the balance of power in Parliament, it had to be communicated by the Speaker as such. There was all this back and forth. Even there were times where MPs were challenging or calling out journalists for not referring to them as. But that is not a formal process. That has to be communicated by the Speaker, that henceforth this person is Mr. Majority or Mr. Minority, and that because that is how it is done. It doesn't just come out of thin air because a vacancy has occurred, and therefore automatically everybody can hold themselves up or can go and sit left or right. If you recall, when we went through the process in 2021, there was a formal process where the side that had the numbers, once it was determined, would communicate to the Speaker that this is our leader. And the Speaker would communicate that this is the majority leader and this is the minority leader. And then everybody accorded the person the right, titles. So how anybody could be going around just, declaring that I am majority, minority, and therefore acting in this kind of way, I found it really, really strange, and it's completely unnecessary. And even in terms of the court case, given the timelines that the Supreme Court gave, 7 days for statement of case, 7 days for joint memorandum of issues to be settled, within 10, 14 days, this matter could have been clarified, and then whatever procedures of Parliament that are needed to be addressed would have been addressed. Why couldn't anybody wait for these things to be addressed? And with all these things, I am a bit surprised, because 10 days will not, for me, take away anybody's rights or anything within that period. So just restraining ourselves and holding on to allow for some clarity, because there has been a lot of opinion as to jurisdiction, correct interpretation, which are all matters of law that needed to be clarified, which the Supreme Court at the end will still be the best place to go to get those interpretations done. So I think some of this conduct really has been a lot of, much ado about nothing, really. And we hope that even now we would sort of allow the process to take its rightful course. There are real matters of law that must be addressed. In our statement, we also made the point that we really need to look at the issue about disqualification of, people close to election, because you leave them with no remedy. When Jesse Kwesi was disqualified, at least you could have a by-election. When you do that close to election, where 90 days before elections, you cannot hold by-election. There's no remedy.
That's what the Constitution says. You cannot hold elections.
Exactly. So there are all these challenges within the Constitution that we need to address, so that it doesn't create these challenges, politically and in terms of our government for us.
We've been hearing from
looking to the future.
We've been hearing from the MPP caucus leader, Alexander Feyomarkin, this morning. He just clarified for us that indeed the bailiff has served the legal department of Parliament with the Supreme Court's ruling. Now the Speaker has also directed his lawyers to file another case staying the Supreme Court's order. How will this pan out?
Well, there has to be a hearing, of course, because an application to set it aside, and this time certainly it cannot be ex parte, because, given the gravity of the issue, this is a matter that everybody should be heard, and should be heard expeditiously, so that could be addressed. Then the Speaker will make a choice once the decision can be made, whether to set it aside, because I believe the Speaker is making the case that in reality he has not made any decision.
But is the Speaker compelled to actually uphold the initial ruling from the Supreme Court, bearing in mind that his lawyers are going to actually ask for a stay of execution of that order? Is he compelled to do that?
Well, the point is that if you have applied to set aside a direction of the Supreme Court, then by implication, you have recognized that the Supreme Court has made a judgment, a decision. So I think that is moot. That's not an argument really to be contested. By making the application, you recognize, and that is proper for Parliament to do.
So per the Supreme Court's ruling, the NPP caucus in Parliament is still the majority. Let's come in the studio. Could you stay with me and just get Winston Amo? You were making a point about this. Now, I'm wondering, with the Speaker filing this new suit, asking for a stay of execution, it also means that he has acknowledged receipt of the initial ruling from the Supreme Court. What happens next?
Well, I have told you that the Speaker, is a lawyer, right? And once they are served, at this point in time, the Speaker would only do what he believes is right. And lawyers have different terms they use. And so he's resorted to what he thinks works for him. And that's why he's also staying. The next interpretation he puts on it is what we'll all find out, okay? If that becomes a situation, that means, okay, so the status quo remains by his ruling, or this other one, we will find out. Because today, the lawyers have themselves become confused as to what is permissible and what is not permissible under the laws of this country. So let's just wait. I mean, my point always is that for the legal questions, let's wait. The Speaker would come out. Once he comes out to announce his next line of action, because what we are faced with right now, for me, the most important thing is that if the Speaker also files a case at the Supreme Court, the same speed that was used in hearing the NPP case should be used in hearing the Speaker's case, okay? So that we move. And, Kodra Asante had made the point earlier that, this is something that could have been dealt with in a 10-day period, and so you probably didn't have to rush into a decision, something that I would associate with. All I want to say is that the judiciary is a key arm of government. And at no point in this country should the judiciary not be trusted by the citizenry, contrary to what the Afrobarometer is telling us. So I am concerned about that. And so now, that is why I say the judiciary should actually take steps to get the trust of the people. And it starts today. It starts today because the same speed must apply to this one. And then at the end of the day, the rule on the case, we will find, whoever it favors can go on a review. Why not? Then we move on in this country. But as I've always indicated, as to who constitutes the majority or minority is not a pressing thing of this country. Okay, elections are 2 months away. As to who is in the majority or who is in the minority, it is not something that is going to change anything, because we operate a system that at the end of the day, every law that you even pass must be assented to by the president. We've seen the president even not assenting to a private member's bill, which has to go back to Parliament, and the Speaker unhappy with it. So this is, yes, to galvanize party core base. Well, that's something that political parties would take advantage of. But for those of us who are watching, I think that much ado about nothing, really.
Is that the case, Raymond? Much ado about nothing?
Yes, when it comes to who sits where. See, the very things that, and I heard the claims that, we repeal the e-levy. We will do the things that with our power we couldn't do. Yes, I'm waiting to see how that plays out properly in this parliament and how that's going to be done. Because how they have operated generally has been that government brings business, then the leadership who represents government would actually be the one pushing that business on the floor. These things will come through other ends, and it's very possible to do so. You recall that Ras Mubarak in his last days in Parliament got some amendments to laws, and one of those were the earliest times we have used this private members bill theory properly in our Parliament. I get that. But I also think that, again, we are not having the bigger conversations about state 2 months to the election at this time. I think political parties are more concentrated on who wins what. And to me, it's becoming very, and as Bryce Simmons has said before, we are not taking advantage of these crises. First, the crisis on the economy and its related debt exchange programs, and subsequently even to do with illegal mining and the things that flow from that, to make corrections that are long-standing, to make corrections that impact the future of this country more positively. I will be very excited if both minority and majority MPs are up in arms over dealings with Galamsey, and how well or how poorly we are fighting this menace, even in the current renewed or additional enforcement that we have put out there. But when it appears that you are seeking to score political points for your parochial partisan interest, you leave out the majority of the people in this country who really do not care about the political point scoring. I hope you get a point. So that is where my difficulty is. That's why I agree with when he says it's much ado about nothing. And frankly, if you do this